keep me humble as I'm trying to dissect this issue of contracts. One, perhaps let me start by saying, from the beginning of the book of Genesis, it was a contract from the word go. We live contracts. Contracts are the instrument that governs human behavior. If I were to just roughly above the surface define contract, is the coincidence of wills. It's where the intentions meet. That's the contract. Contracts exist with elements. One of the elements, in fact, if these two elements are not met, that's not a contract. A contract, there must be an offer. There must be an acceptance. This thing that my learned brother from the bank was talking about, consent. There is a requirement of consent throughout our lives. There is a requirement of consent. Jesus Christ offered himself. Whenever our church is conducting altar call, that's an acceptance. And that's a contract. But the difference is that that contract is eternal. It's very much important, even if we call visitors that have not accepted Christ, to tell them that I encourage you today to take that altar call serious. It's the only contract that is valid forever. There's no death that do us part, even unto eternity. That contract exists. But basically, there is a variety of contracts. There are spiritual contracts, there are cultural contracts, there are social contracts, there are corporate contracts, which we spend our whole money dealing with those, and there are governmental contracts. The people that enter into contract according to this world that we're living in now are the natural person, juristic person, and what we call government or organs of state. That's where we have what we call business. It's the natural person is yourself. Any human being above the age of 60 years, at least to 18 years. In fact, when they acquire majoritarianism, it is then when they are 18, it is then that they are eligible to enter into social contracts. There's always evolution, but I can't deal with the seafloor linguistics of contracts. It will be a serious confusion and wrong matrix. But it is necessary to inform you that the fact that you are of age, you are a natural person. But national personality starts way back, but I won't enter, that will be law of persons. But what is important for you to be eligible to sign a contract, it's a must that at least you must be above age, which is rebuttably 16. But by law, at least you should be a majority, which is you should not be a minor, you must at least be 18 years. That is another issue. Person from here downwards and many more, there's what we call forms of business enterprises. There are close corporations. Zikona is abolished by the new amendments now in one of these formations. But some will catch up when they meet my learned brother there in the banks. But what is important, there are many business enterprises that enter, but the most integral part when you're entering business, whether you're a corporate, which is you're a business enterprise according to legal terms, you're a juristic person, they are always trying to manage risk. Contracts are about risk management. If you are entering into a contract and you ignore the fine print, you will always find out later. And sometimes in a good way, sometimes mostly in the worst way you can ever think of. I'm hearing a sad story in Luthando right now, and I'm asking myself, where was the interpretation of that contract? Because her will is not enshrined in that contract, but she's suffering as a result of the contract. So when you enter a contract, whether as a natural person or a juristic person, enter with full first elementary thinking of risk management. Take time to read a contract. Why I'm saying so? Any dispute that arises from a contract is governed by what we call parole evidence rule. Once you sign, and it is a contract, maybe even if it's in accordance with the general conditions of a contract as gazetted, once you sign it, it's binding. It's enforceable. Apart from just binding, but contracts are enforceable. If you analyze contracts, there are traditional clauses, for instance. The breach clause. Most of the contracts are forced by the general conditions of a contract as gazetted by government to have specific non-negotiable clauses. Every contract ought to have termination clause. Every contract ought to have, when I'm talking about corporate contracts, ought to have what we call breach clause. Breach clause traditionally gives you 10 days to remedy the problem. If ever you are the one who's in default, or they are the ones that have not paid you on time, they are in default, you have a recourse in law under that one clause called the breach clause. Read that clause, know what it means, know what it says. It's very important. Read the contract as if tomorrow you might find yourself in a different attitude with these people. Don't read it on excitement. Read it, that's what we meant when we say risk management. Read it as if there might be a dispute that might arise. If there is a dispute that arises, what are my remedies? Maybe let's deal with remedies. In the question of remedies, there are three in contracts law. I'm just talking about contracts, not contracts management now. Contracts law, and there's a difference. In respect of contracts law, there is restitution as a remedy, where you take back what let's say you bought, it's a contract of sale, you decided to buy a fridge. And then it happens that whilst you are trying to buy this fridge, it has a patent defect. There are things that are called patent and latent defects, things that you don't see, sometimes by the naked eye. And you want to terminate this contract between you and, let's say, furniture shop, okay. You have to, by all means necessary, start the breach clause. Understand that if ever you are making an application for the restitution, okay, will take his fridge and your money must go back to you. That is restitution as a remedy in contracts. Rescission. Rescission speaks, in fact, sort of gives proper expression of termination. You are rescinding, you are just cancelling it. No one, sometimes, most of the time, if I were to take marriage and say it's out community of property, even if it's in community of property, when you decide to rescind the marriage, to cancel, to terminate the marriage, one of the remedies that you are having, according to law of contracts, is called rescission. And then the other one is damages. All right. Let us go to, for an example, Well, I don't bore you with these things. I was just trying to put things into perspective. There is variety of contracts. There is sessionary agreements. There is shortship, which they've been trying. I've been listening to them. They're actually talking about shortship throughout. There's a defense in shortship called excursion. If ever let's say you said it's a collateral, according to bank terms, we call it shortship agreement. If ever sometimes you take a decision of saying, I take surety on behalf of so-and-so, that particular person fails to pay the demand, it is necessary before they go against your assets and what you owe, you can raise a defense called excursion. Excursion says, deal first with everything that the principal debtor owes. Then when there is absolutely nothing, you can then come to my assets, if ever you take shortship. Then there is also lease agreements, which we all know. But I want contracts are a good thing as well. I see that all of you are tense now. All contracts are subject to a variation clause. The parties automatically does have, whether they call it amendment clause or variation clause, which creates automatically what we call addendum to the contract. So a contract can be varied by consent. And I must make mention of this because consent is one of the integral elements of contracts. A contract must be unequivocal, a contract must be ambiguous, a contract must be constitutional. I heard many of you talking about wills here. Even if a will would take the sense of a contract, at least this must be aligned with the constitutional aspirations. You won't say, when I'm dead, I wish you can just wake up and beat my mother. She used to beat me when I was a child. That will not be a proper will. It will be unconstitutional. You see. So a contract must be within the prisons of the law. Then we are having your OTPs. Many of you have met those. You are having the deed of sale, deed of transfers, transfer of a house. You are having marriage. Marriage is a contract. And marriage is changes. Let me take interest on this one. Well, marriage is not all lost when you are in community of property. It varies according to the Matrimonial Property Law Act. You can change the nature of your own marriage and say we're changing from in community and we're making an application to out community. You can do that. What I have experienced in marriage, they are not changing marriages, rather than when parties are fiscal or cash strapped, what they normally do, they don't take lawyers' advices. Instead, they go and dissolve a marriage with the hope of getting pensions of the other. Instead of going to Obo Mr. Mbambo and get the proper advice that you can actually even avoid liability in this sense. So other marriages are actually affected as social contracts, but are seriously affected adversely because people don't consult attorneys. Masisondele kule daba le will, because it has been an issue that has taken toll here. Kwindaba ze wills. A will is the most simplest, best decision you can make for your children. It's the best. But it will influence was into a tree. A will, ideally, must be written by a person who's not unduly influenced. That's why he was talking about, as a spouse, you were found as one of the witnesses in a will. Somewhere, somehow, that raises eyebrows until you prove it thoroughly that indeed. But the fact that you are party to this will end, it seems as if not only 50%, but 80% comes to you. It means you unduly influenced that person. Therefore, that will be revoked. What we call revocation of a will. It will be rendered null and void. Then it must not be done in a form of a mistake. It must be done voluntary. That is a will. Without any undue influence, without any form of a mistake, without being under duress, being threatened that if you are not writing this in this way, in this particular will, I'm dealing with you. It must not be under that. It must be done free and voluntarily. That's a will. A will is different from a trust. A will deals with lento kutwa lilifa. You must not be here when you are reading it. Then you die testate or interstate. Interstate means you died without a will. Testate died with a will, which is the perfect way of sending your last testamentary wishes, saying, I'm departing. If I depart from this world, we believe most Christians, we live twice. We die and we live into glory. So normally, you leave everything into perspective. It makes it easier to devolve your estate. Makes it very easier to devolve it. But when you are without a will, the saddest thing, even children that you did not, if ever you had extramarital children, for an example, in the eyes of the law, they are equal to the marital children. There's no discrimination. And mostly the law favors what is best for the children than any other person here. Children are under the category of what we call the vulnerable groups of society. So categorically clear, I wanted you to understand what the importance of will is. And to die without an estate, there is law that governs that. And the estate, or rather the question of estate, begins when you report the estate. Most of the people here are having estates or are living on estates without reporting them, which creates family disputes. What makes people fight after the death of an important person in the family is because sometimes the people themselves did not report the estate. They just divided. So totally. As our meetings after funeral. As those meetings are the ones that are dividing families most of the time. Simply because people are not serious about the question of drafting a will. A will is free during September to all law firms. You can ask Mr. Bam. Everybody who wants to draft a will during September is the wills month. It's for free. And the mandatory duty to us as attorneys to assist you accordingly. If we have failed, you report us to the Law Society. But we must assist you in terms of wills. So, I don't want to waste more time. There's contract of employment is regulated by specific legislations as well, subject to many different catalog of atmospheres. But it's governed, it has systems in place. I won't enter into sections, although I'm tempted. But I will not, it's not necessary. So, in respect of contracts, elements is a contract system that we offer an acceptance. Sadlula sathi might be unequivocal, might be clear what you want. Two, might be ambiguous, might be clear nalapho ba yinjani, be concise to what you actually wanted Be will yakho. It's your will. It's your own intention reduced into writing. But it will be a mistake to say there are only written contracts. There are verbal contracts, and they are enforceable. I was shocked on the side of marriages when you deal with the question of lobola. Lobola sometimes is not even written in terms of minutes as to what is happening, but you know that you have a recourse out of that contract, so you can go and claim the lobola man from the lobola eater according to customary law. So I'm trying to appreciate that there are verbal, there are verbal contracts that are honored in the eyes of the law, as long as the people agreed. But we as attorneys, it is our duty, we're duty bound to actually advise you to write your contracts down. Let's take for an example, issue indaba National Credit Act, as he was dealing with that. I'm saying that because he was talking about loans. There is National Credit Act that protects people. And you report to these institutions if ever, let's say you were a very good person, you entered into contract with them, you're working, and suddenly the boss decides to say, I'm tired of Queenstown. Mr. Mbambo would say, I want to go back to Cape Town or KZN and close. And then the job is out, and then you are in trouble with the bank. You report to them. National Credit Act governs the loans, the credit you get. You are not without defense. You report to them, you tell them in time, not for them to find out, but before that I'm having this difficulty. That's what contract is. Contract is not the end of the road, but just an instrument to manage behavioral patterns of the parties and serves as evidence. It is subject to adjustments if it's confronted with the question of, let's say, employment now is over. You have to inform the bank. The bank will, or the salary, you are demoted, the salary depreciated or degenerated into something that you can no longer afford that loan. Talk to the bank, enter into a different contract. That's where addendums come from. That's where other forms will be brought as part of your file. So understand that when it comes to contracts, it's really not a scary thing, because black people sometimes, I'm black as well. But I'm saying, we black people, we tend to be afraid of screening the fine print, to be overexcited by what we want, not reading the entirety of the contract. Whenever you feel that this contract leaves a thorn, you have a right to renegotiate the contract. It's allowed. It's in the traditional provisions, in the general conditions of a contract, gazetted by government, to ensure that all the contracts in our country are in accordance with the constitutional aspirations. Then, I was a bit lucky when I was growing up to serve government in 2014, East London Human Settlement and Province, contracts management. I was dealing with construction contracts. If you are dealing with construction contracts, it's a total ball game, and there is one Bible called the JBCC. You have to know that JBCC, it's part of the contract. Although there might be, let's say, funding agreement according to how they name them there, but JBCC will be at the end. It's like you cannot claim and say, I did not know this. You have to comply. When it comes to contracts, there are two salient issues: compliance and legalities. You deal with those. If ever I'm talking about construction contracts, the millions, 92 millions, don't be excited by the appointment letter of 92 million, check the demands of the JBCC. Check what that constitution says. Check the provisions of the contract on top. Are they in accordance? And then understand this as well. Government, when you're doing business with government, government has what we call Penalty Clause Act. And the governmental contracts have a turnaround time of production called the Project Implementation Plan. When you fail to deliver, probably some of the reasons, my learned friend refused you a loan, you see, because they're not front-loaded. You always create value according to PFMA and then get paid later. When situations of that nature occurs and you go to the supplier you was talking about or other people and then you're making other deals outside the one with the government, you must understand this, that there is also what we call sessionary agreements, the one I started with. You sign a session. When you sign a session in a very paraphrased way, you are surrendering your rights to a future claim. That's what sessionary agreements, most of the time, are used for on governmental terms. So, you are not without recourse, even if you have signed a contract with government, but when you could not shoulder it anymore, there is an avenue of signing a sessionary agreement. So the question of the whole question of contracts, seriously speaking, it is not a scary episode of life. It's just that people must understand that they are negotiating at an equal position. Don't negotiate in the position of weakness. If ever you're going to enter into an agreement, do not at any given point negotiate from the position of weakness. Moreover, when you're looking at contracts in the context of the nation, even the constitution we're having, even the new dispensation, democratic dispensation we are living in, was as a result of what we call contracts. Every party was called in Kodesa. They negotiated the future in the South Africa they wanted to see, and they've created a contract that is binding to every person called the Constitution. So it is true that we are all living in contracts. Even if you want to ask for marriage, you have to offer, and then you can't force yourself into it. There must be acceptance. Without acceptance, indeed, the contract does not exist. The avoidable and void contracts, I've already tried to explain the issue of void or null and void contracts, those that are unconstitutional. Another person would wake up, but I'm not sure, I think 2016 that changed. But another person would live or create a contract that says, I'm going to pay you this much. You go and kill so and so. You can't take that contract that has been written in that fashion to court and ask the court to enforce it. That contract is not void, it's unconstitutional. It threatens the very provisions of right to life. So the contracts must be consistent with the Constitution. You can't have a contract that is not consistent with the Constitution. So I want to say, because they call no and booze are cool, they're ready for questions more than presenting to you guys. Yeah, I want to tell you that whichever we are looking at question of contracts, addendums, additions to the contract. They add, but they don't change the complexion of the contract. If ever it was a construction contract, it remains a construction contract. But when you addendamize, you are just variating particular clause, or whether it's duration clause, for instance. Most of the time in government, they love to vary time. I understand why. Sometimes the weather conditions behave differently. Beyimvula, kanowa, throughout, yet construction should have started last week, and they can't. But most of the time, the addendums does not change the complexion. They are just an addition to the same complex contract that is before you and government. That's how you conduct contracts. And then one other thing that I think is important, there are international contracts as well. But in the language of the international or global village, as I like to call it, they call them treaties. For instance, if I were to make an example, even if Trump can decide to come to South Africa and attack us and kill so many people, we can't take him to the ICC because it's not a party there. It didn't sign. Those are international contracts. You can't have him like we did with Israel because they are part of the ICC. If they have not signed, they are not party to that treaty. So there are those international contracts that are called conventions sometimes, but in another synonymous word, they are called treaties, and so on and so forth, as the English would want to call them. But the reality is that they are only binding to a person who's a signatory. You must be a signatory for that contract to bind. I remember this other time, there was a time in South Africa where we were requested to arrest and take all the properties of Mugabe. There was that time. But South Africa tried to negotiate. But in terms of our contract, we should have done that. We're party to the United Nations. So there are those contracts that are governing, diplomatically, governing the space up there, which is the global village. And then there are domestic contracts. Question?
Sorry to interrupt.
Yes.
I'm caught by these contracts, Yeah, I have a situation.
Yes.
Little big. In our future planning, we want to do export. Now, what we decided to do was to get into bigger wholesalers so that we can at least pace ourselves for other markets. Now, this company, Masnat, says we have our own contract or compliance documents and not your South African one. Now, I was challenged there. I'm like, you are in my country. You are telling me that I should abide by your laws that govern food and security. And yet this food is produced here for the people that are here. And you are selling this food for people that are here. But it must be governed by a different law. How does that work?
All right, perfect. Remember, the strength of our constitution, why the whole world loves the constitution, but the nationals, the actual locals are not happy because it's not really implemented, is the fact that it allows, in terms of what we call jurisprudence, it allows the application of foreign laws. But it must be done according to the Constitution. There is a specific clause that governs that. But however, I think it's section 233, I'm not sure about the section now, but it's in the Constitution. It permits, even if I'm going to court for an example, I want to address the magistrate on an issue of human rights. Human rights are universal. It is my duty, if I want to use a foreign decision, to do it according to that particular clause. Which means the laws of our country are not allergic to the application of other laws from other countries, as long as they don't shift the center poles of constitution, as long as they are consistent with the constitution. Moreover, this issue that you are raising now, remember, you have freedom of choice. I think it's section 16 of the constitution. You have freedom of choice and of trade as well. So you choose careful. For instance, if ever you are having two offers internationally. China wants your product. USA, in this political climate, wants your product. You understand the tariffs, because the international trade law will teach you tariffs now. You have to know how expensive it's gonna be, which country is user-friendly in terms of the treaties, which country can work with South Africa. You have to look for that first. Which country, diplomatic engagement, do we have diplomatic engagements there? If what type of the other part, or the other countries' the value systems are? What type of value systems are you actually dealing with? What type of people? Same applies domestically. You should do that, because I said initially, costs are about risk management. Don't forget that. You have to have methods to mitigate the risk. If it's too expensive, sell for America, sell for China and Russia. Don't choose a contract that will be heavy on your shoulders, because the whole reason of entering into contracts to unlock destinies. So contracts are actually instruments that are used amongst the people to unlock destinies. If ever you have a desire and your destiny, for instance, is to open your own car and so on and so forth, and you're looking for a financial institution or whatever, there are many financial institutions nowadays. There are the ones that are legal, there are the others that are not legal. But either way, try by all means. Try by all means. Try by all means to do things within the law and to do what's best. Choose the partners in a contract. The most bad thing about a contract is the same, I think it's the same problem when it comes to marital contracts. We are quick to choose on the moment of jubilee. We are so happy. And you have tried this person. But you have not checked what my learned brother was talking about, these three things. You don't. You see a beautiful woman, she has a career, you have no idea. So even if you are choosing a marriage partner and you're serious, let's say you're serious, you're looking at these things like my brother. Do the same thing with contracts. Do the same thing with contracts. But when it comes to government, contracts that exist between government, let's say municipality and the province and so on, it's a bit different. The penalty clause does not apply. They have intergovernmental relations, and it does not defy logic at all, because it's pretty much clear that they are getting money from the same bucket called treasury. So it will be useless for a municipality to sue human settlements, because the money to pay municipality or to province will come from the same bucket. So when it comes to the intergovernmental contracts, there are no penalty clauses amongst them. They are always contracts on VAT zero rated. you see. So they are all regarded as vet vendors. So there's absolutely no reason for them to create a different contract. It makes sense in terms of even if you were to penalize another person, it would not yield any tangible fruits. So those are the varieties of contracts. But I want to also indicate the issue that there are political contracts. And next year, we are having, as a nation, political contract. All the manifestos of all the formations that are governing this country are offers. They are offers, if you interpret them through the lenses of a contract. They are all offers. Your vote is an acceptance. So it is a fact that we live, but do the same thing, my learned brothers, advisors. Look at these things. When you are voting next year, look at these things seriously. They will give you an offer through manifestos. But before you accept, look at these three things. Yes, are they trustworthy? So I'm saying the world itself is being governed by contracts. They exist almost everywhere. Even schools before now, it's even more serious now. You have to sign if ever you're taking your child there, even to the policies that are not having indigenous perfumes of an African. Sometimes you can say that this particular clause, but this is my child, but you have to sign code of conduct, even if you have reservations. So contracts are existing everywhere. But what I can actually ask you to do, understand that there must be an offer, and the offer must be clear, must be unequivocal. It must be constitutional. It must be ambiguous. You must understand the offer. Do not jump into accepting a contract. Even if, my sister, they're asking for a marriage, look at the offer. You see? And my brother gave us a method. I wrote these things down because it's amazing. You look at it even this way. You see? But look at the offer. Look at the offer. So in the context of corporate contracts and governmental contracts, with the little time that I have, I have decided to paraphrase and try to explain who are the role players, natural person, juristic person, organs of state, and how to do business with those people, you see. So contracts are in that fashion in particular. The remedies, just for you to remember them, there is always a remedy to cancel a contract, rescission. There is always a remedy for restitution. For instance, in a contract of sale, many people don't know. When there is a patent or latent defect on the product you've bought anywhere, there are other legislations like Consumer Protection Act. They come into play into defense of checking the alignment of the contract, whether the contract is consistent with the aspiration of a right to trade. In terms of are they echoing the value systems of the Constitution and the future we want to see? So, for instance, if you take Section 55 and Section 56, you are entitled to a refund. Whatever that you bought, if ever within 6 months, it just decided to go and it's defective, you have a full right to take a recourse in law and demand for a refund. So those things are applicable, but it's just that people don't pay too much attention to them. You are in dire need of this water. You quickly take it without even checking if the date is still on or what. Within no time, you realize outside the shop, after the transaction has occurred, that no man, this product has expired. You have Consumer Protection Act. You can go back, cancel the contract. You see, it's a sale, contract of sale. You cancel the contract. It's what we call restitution. They must take their product and give you your money. So for now, let me park there. I'm ready for questions. Any questions? Yes.
I think most of us, especially if you're still starting your business, this is the challenge we have. I'll just narrate a small scenario. Oh, hi. Okay. A certain company or business orders products from me, cabbages. I'm just making an example. Now, they don't specify to me the size of cabbage that they want. They say they want good cabbage. More or less, it should weigh at least between good sales, between 3 kg and above. So I bring this cabbage, it's weighing 3 kg. But now, when it gets there, he complains that this cabbage actually does not have good leaves. So I'm rejecting the whole stock. Now, you can't cut a cabbage, 1,000 stock, cut it for someone, and then when it gets there, he rejects because shelf life here is too short. Now, in that case, what do you do? Then he rejects it, and because he is a big business, you are a small company. What recourse do I have? Yes, you're talking about restitution and all of this, but there is no written contract that says he wants this kind of cabbage. And I'd already covered, and now it's a loss for me because I don't have anyone else who's going to buy this cabbage. So what do I do in that?
All right. Hallelujah, fastly.
Okay, I just want to go back a little bit, say, about the lease. I just want to ask, suppose you take a company or you take a business and the previous people had a lease and you are the new person, you are taking over. The lease is still written with the old, the people that you took business from. You are taking business now. Now you want to continue, isn't it? We change everything. Now the handover, take over, you find that from the people you took from, they have outstanding debt. And you are the new one. So how do you go around it? Because I have that kind of a situation. The lease is not on my name yet, because you still want them to clear. And now when we are going to the company that we are renting, you know this company has got issues. Maybe at the end of the day I will win. Transnet. They now go back and then they say, no, since it's not written on your name, everything has to fall off. Something like that. Is that possible? Thank you.
All right, man. Uyele kwi-podium. Ngizobonakala kahle, ndinibone kahle nami. All right, thank you for the questions. Let me start with the last question. If you are in business with the organ or state or a company or a parastatal, point number one, you must be in that contract as a party. If it's a lease agreement, there is landlord and a tenant. Sometimes they say leaser and a leasee. Those are our terms as attorneys, but it's the same thing in terms of meaning. The person who has the right, according to the contract, is the one that is tenant. If you are not a tenant, you ought to enter into a new agreement or agree on variation clause with the other parties, let's say the landlord, to actually variate the contract, create an addendum. But most of the time when the contract has been terminated between two people, let's say the state or the parties, if I were to put it that way, a new contract is born if you're a new tenant. You can actually enter a new contract, but probably on the same terms. But the contract that was binding the last tenant is not binding to you.
Not yet, but still, it's the process that they haven't done.
Yes.
So that keeps you always on hold because they have to clean.
I understand, but contractual, there's what we call parole evidence rule. You can't bring something that is outside the four corners of a contract as a dispute or grievance for that matter. Because everything that has been tabulated by those respective parties still governs them, and they call it terms and conditions sometimes. They are still at play up until they terminate that contract. When they terminate the contract, it is only then you can enter your own contract with the terms you want to see. You see. So in a nutshell, the liability of another person cannot be imputed to you. And there is not a single grain of contractual obligation that in terms of the law can be imputed to you or go against one. But what I can say also, it's different sometimes when it's companies. When it's companies or government, when a police is in a contract of employment and decides to assault a person unnecessarily, and then that person sues the organ of the state, SAPS, the minister, that's where you start. You sue where there's money. So when you actually going against that police person, you sue where there's money, but vicariously you cite the person involved. So in contracts, there's what also called vicarious liability. It exists when you were advancing the interest of another entity as a member authorized to do so. When it's not government, let's say it's companies now, against each other, it's applicable, but the person who would act normally on behalf of any company in South Africa must have a company resolution to do so. So only an authorized person can be held vicariously liable with the company. But if that person acted outside the authority being given to him by the company in the form of a company resolution, the company is exonerated from any form of liability. And you will be personally liable. Then let's see apa ku Antando. Antando's question. Well, if it happens that you are entering into a contract with this particular person. No, can you repeat your question? I'm thinking about that one.
Which comment should I give? Okay, let's say pick Masiti Spa. Spa says, okay.
Oh, all right. Thank you. I remember cabbages.
Yes.
Yeah, now I remember it. All right. In the context of that, remember when I actually enumerated the the remedies of a contract, there's also what we call damages. Ne? If you've entered into a contract and you've agreed and you signed in principle, and you brought what is according to the spec, they tell you what they want. You bring it as it is. And then they tell you, and then you went through serious loss financially in trying to deliver what is required. You have a recourse. If they are terminating the contract, it is within their right. But for all the damages you've suffered as a result, you quantify them, and then you ask His Excellency Mr. Mbambo to take the matter to court. And then the court will award you the damages as a result of an existing contract. The court will see that contract, quantify, see that you've served your part. The person now who is in default is the one that is not paying. You see? So you do have a legal recourse. Don't leave it there. Come to lawyers. Come to us. We'll fight. We'll fight. We'll fight. I think for now, is it okay? Okay. Any other question? Yes, sir. Yes.
Maybe just following up on this latter question you responded
Yes, sir.
to.
Apologies.
Thank you very much. No, I'm just, my curiosity was raised when you were responding to that. And you are maybe recommending that the complainant must go to court. I'm thinking now in cases where you do not necessarily want to go the legal route, and you have you have a party, a client that you are serving, a very powerful client, so to speak, and you honor your part of the contract, but he refuses to honor his, and you are not necessarily interested in going the legal route. Maybe you can as a very last resort, but you don't want to go that route. Maybe out of fear of being closed down as a business. I want to take that approach. You are dealing with this very powerful client. Maybe it's government for that matter, and a big boss in that particular institution or department you're working for threatens you and says, you will never make it, you will never get a project or contract. Should you even think of taking us to court? Essentially that closes the route of legal that you were going to take.
Yes.
Now, what then should you do in that case? Because there's a lot of such cases where people are not paid on time. I think we get a lot of that. Those complaints of such nature. Years go by, they don't get paid, and when they demand their monies, they are told you will never get business anywhere in South Africa. Thank you very much.
Thank you, sir. In conflict management, when we were being trained for it, we were told that there are two methodologies we employ whenever there is a conflict. It's either you deal with it legally or politically. For instance, if you were to ask me as an attorney what to do in that situation, I believe competitors, variety of societies, they respect strength, not weakness. I would take a different attitude of saying, let us, if you were to enter in with that problem in my office, let's go to them. And if ever they don't want to negotiate, let's say you say to me, I don't want to go and play a hardball yet. My analysis would be immediately, oh, you want an alternative dispute resolution. Let me call them first. But I will already tell you the posture that I've adopted, that legally you have a case. And this money can come within a specific period of time. And you can recover it. So that will be a legal mind in me. Political methodology would be, maybe let us exhaust this alternative dispute resolution. Go visit, write a letter to them, request an appointment or in any fashion, but to meet with them. Try to try to resolve the problem. But telling you still that if it's not resolved, there is still a recourse. So I would never advise you to shy away from your right to a recourse legally. I would never. But there are other institutions politically that are existing. For instance, umem loa di mazela kwi lento kuthiwa business forum. They have business forums and they are very vigilant and bayalwa. You see, they are fighting for all the SMMEs and what is due to them, and then the government is listening to them. Remember, government in a democratic state, it's you. The people that are officials are public servants. Whenever there is a servant, there is a master. And the master is the people in a democratic state. It's the government of the people, for the people, by the people. You remain government. No one can say you are not government. As a person, as a citizen in South Africa, as a human, as the people, you are government. It should not shift by any gospel that is preached by different people in terms of political formations. It should not shift. You should understand your stand, that you are the government. And whatever that you demand to a servant, which is a public servant, it's supposed to go at least according to the books, which is according to the law. It must comply. There must be compliance and legalities. The fear, unfortunately, we are trained in a different institution where we must fight without fear or favor. I would never encourage anyone to harbor any fear. It is time for the people to stand up for what is right.